no jurisdiction to undo that appointment. This is what they're telling you. You cannot undo a deputy presidential nominee who has been sworn in and has taken office. This is what they're telling you. At any length, they tell you, this is a political question, don't even look at it. That's why they began. Don't even look at this. The president knew what he was doing, take him at his word and at his actions. So that's one side of the balance of the scale. On the other, you have a sitting deputy president who is before a court of law as he ought to be. If in the unlikely event his petition were to fail, all he does is go back home and we swear in the new one once the petition is dismissed. But conversely, if you swear in a new deputy president, you kick in motion a whole series of events, including a president, a deputy president who is now exercising constitutional mandate, who is chairing cabinet committees, that may ultimately be found to have acted outside the Constitution of Kenya. That is the Peter Gatirau Munya decision. My lords and your ladyship, the decision in eternity. It will be a turning point as to whether we continue being a constitutional democracy or a dictatorship and an autocracy. I beseech you, do not let us go down the path of autocracy and dictatorship. Thank you for the privilege of your attention and your time. Unless you have any questions for me, I'll hand over to one of my colleagues. Thank you.
Thank you.
My Lord, my name is My Lord, my name is Kibe Mungai. The team leader is Paul Muite, Senior Counsel, assigned this application, the one from Kerogoya, to me, Professor Ogada, and Mr. Ndegwa Jiro. As I had already indicated to the court, and with the benefit of the submissions from my learned colleagues, we shall try to do our business within an hour. So I'll start first, followed by Mr. Ogada, and then Mr. Ndegwa, for purposes of presenting that application. My Lord, let me start by thanking the court for the decisions that it rendered on last Friday on the questions of directions that it gave for the hearing of the petitions that are before the court. My Lord, I confirm that the process of amending the various petitions is ongoing and will be filed in accordance with the timelines fixed by the court. My Lord, going by the timelines that you gave, it is also my pleasure and appreciation, and that is in ensuring, with the compliance with the Mutunga rules, that it is possible for your lordship to ensure that in the same way that the month of October we dealt with the political aspects, with the political phases of impeachment, that it is now possible, courtesy of your directions, to ensure that we can be able to have a judgment on merits for purposes of the various petitions that are before you. That would be an absolutely important issue for this court to remember, because it is being made as if it will not giving due process and ensuring substantive hearing of this matter, that we shall be here until forever. Allowed all these businesses can actually be concluded within the month of November. That being the case, my lord, by way of introduction, let me say two things in my own words as counsel representing, I believe, the 4th to 8th petitioners who filed the application that is before the court.
The date of your application?
Yes, my lord, that is exactly the issue. 18th, my lord. The application was filed on the 18th of October. Yes. Okay. My lord, 18, it is supported by an affidavit sworn by Honorable David Muni Madenge on the same date. My lord, for purposes of the documents, let me start there. We have filed submissions. The submissions were filed yesterday. There is a supplementary we filed today, and we have filed various responses to the affidavits to set aside that my learned colleague, Mr. Ogada, will be referring to them. My lord, that being the case, I wanted to say that by way of an introduction, there are two broad issues that I can be able to say. My lord, thank you. Yes. My lord, the first issue is that the petitioners moved the court petitioners applicants moved the court in Kerugoya in view of the fact that under Article 3.2 of the Constitutions, every citizen of Kenya has an obligation to defend and protect the constitutions of Kenya. That's a broad mandate. And of course, further to the other mandate, that under the Bill of Rights, from Articles 19 to 23, where the Bill of Rights is being violated, they are permitted to come to this honorable court to seek for the appropriate reliefs. And therefore, that is the basis upon which they came and have moved this honorable court. My lord, the second broad
the discussion along the topic which they have been given, and thereafter we'll go to the next session before we combine the plenary, so that we can leave here in good time. So I think Patricia, you'll start, then Felicia, and then Matthew Mutiso.
Tumekuwa kipaumbele kudadavua taarifa za kutwa kila siku kwenye Open Forum Political Show tangu Januari, sasa Disemba tunayo. Tunachukua nafasi ya kipekee kusema asante mtazamaji na mpenzi wa kipindi cha Open Forum Political Show na Sound Candid Talk. Unaposherehekea sikukuu ya Christmas na mwaka mpya, tunakuahidi mema zaidi. Sound Candid Talk, we wish you Merry Christmas and Happy 2025.
To create civic education.
Watu wa Mungu, Bwana Yesu asifiwe. Kipindi cha mahubiri kimerudi tena kwa kishindo kwenye Sound Candid Talk. Tunakufundisha, kukuelimisha na kukutia moyo kwenye Daily Bite. Mafundisho kamili ya Biblia kila siku kwenye runinga uipendayo ya Sound Candid Talk.
we urge you to have a look at them. But we also filed some additional written submissions on 28th October 2024. Both of them are entitled Petitioners' Submissions on the application dated 18th October 2024. Let me move into the substance of what I want this court to consider this morning. And I want to make some overall observations, my lords and my lady. I prefer to look at this case in this court as an opportunity for our constitutional order. Whereas I know that there may be Kenyans out there interested in this matter, looking at this moment as a challenge to our democracy and a challenge to our constitutional order, I bear a message of hope. I want us to look at these proceedings as an opportunity for our constitutional order. So the challenge for me, my lords and my lady, is how we shall seize and use this opportunity. I look at it as an opportunity for our governance institutions. My lords will remember the words of the late Justice Chunlal Bagwanda's Madan in that famous case of Githunguri versus Republic, where he urged Githunguri to run unto the hills, face east, and thank his gods that Kenya is a country under the Constitution. I see this as another opportunity. I beseech this court to urge His Excellency DP Gachagua to run to the top of Mount Kenya, face east, and tell the world that Kenya is a country under the Constitution through the opportunity presented by this case. I see this case as an opportunity for the judiciary, and I'll be elaborating on this point in a short while because of the behavior of other organs of government in the recent past. So I see this as an opportunity for the judiciary. I see this case as an opportunity for righting wrongs and not for perpetuating wrongs. I have had the privilege of participating in these proceedings from the National Assembly, through the Senate, through this court. And I thank God and thank my client for that, because out of 50 million Kenyans, I have done nothing special to deserve this opportunity, but this somehow fate has conspired to give me an opportunity to participate and witness these events from the front benches. What this case has taught me is just how perilous we stand as a country if we depend on our legislative and executive institutions, and very recently, our constitutional commissions. Our remaining beacon of hope, my lords and my lady, is this judiciary. I have one question for you, my lords, my ladies. Will you drop the ball, or will you hold the ball to the finish line? A brief history of what you will find in our amended petition, by way of paraphrasing, is that on 18th October 2024, this country witnessed an unprecedented hurry by our executive, legislative organs, and our constitutional commissions to beat our constitutional order. I'll demonstrate this shortly. On that day, 18th October 2024, we witnessed an unprecedented hurry. In fact, I would have thought, speaking for myself, that our country has become super efficient. But I discovered that no, We were still waiting long to get our national IDs. We were still waiting long to get our passports. We were still queuing for long in our hospitals for health services. That this unprecedented hurry was for a specified project to beat our constitutional order. And why do I demonstrate this? A process for which the Constitution of Kenya prescribes 74 days at Article 149, Clause 1 of the Constitution was truncated and executed in less than 6 hours. Clearly, we may have varying definitions of the word hurry, but we can build consensus that this one is undisputedly unprecedented hurry. Why did the makers of our Constitution prescribe 74 days maximum in Article 149, Clause 1? Different analysts may give it different interpretations. I beseech you to find whatever the scope of interpretations, the following will fit into them. Number one, it must have been to give the process optimum transparency. Number two, it must have been to give the process optimum accountability. Number three, it must have been to give the process procedural fairness. Because whereas we know that justice delayed is justice denied, we also know that justice hurried is justice miscarried. And finally, it must also have been to give public participation in the process under Article 149, Clause 1, some chance. Allow me to submit at that juncture from the very outset that the process undertaken by the President of the Republic of Kenya, by the Ethics and Anti-Corruption Commission, which was mentioned in the President's communique to Parliament, to the National Assembly, by the IEBC, that was also included in the President's communique to the National Assembly, and by the National Assembly itself, did not even pretend to have an iota of public participation. Even the pretense of public participation was now taken away. We will demonstrate to you that the process between 1st October and 17th October, the process between 1st October, when a notice of motion was given in the National Assembly, to 17th October, when a resolution was taken by the Senate, had pretenses, half-hearted pretenses of public participation. That will demonstrate. The process on 18th October, buoyed by any lack of checks, buoyed by the fact that any attempt at checking the institutions had not yielded fruit, now they became brazen. They now undertook a process on 18th October, now completely without any pretense of public participation. There is no single Kenyan who was given a chance to ever say what their take is on Honorable Kithure Kindiki, my law lecturer of yesteryears and a fundamental scholar, my good people. No Kenyan was given a chance to give any thought on whether or not he is suitable to be deputy president. No member of the public, no memoranda was received, no meeting was called anywhere for anyone to give any thoughts. No email address was given to be crushed by Kenyans, as we now know Kenyans can do it. Completely, no pretense at public participation. I'm emphasizing these points, my lords and my lady, to demonstrate the point I made earlier, that we have now been taught how perilous it is for us to rely on our executive institutions and our legislative institutions and our constitutional commissions as defenders of our constitution. We are now left with only one institution, this judiciary. I don't know where that noise is from within here. I think if they're doing renovations, they may be told that this is so important a day for renovations. We may defer them to another day. And let's face it. Let's face it. The process of 18th October 2024 took 6 hours as a deliberate scheme to defeat each of the principles and values of good governance I have alluded to: transparency, accountability, procedural fairness, and public participation. Who did these violations? We are also here to call people to account. Who did it? Between the time we left Senate around midnight, between the time Senate closed business around midnight of 17th October 2024, and the time we woke up to the presidential communique of 18th October 2024, in that night, the Bishop Oginde-led Ethics and Anti-Corruption Commission is documented in the President's memorandum to have received, processed, and given a clearance to Honorable Kithure Kindiki that night. My lords, history is important, and I may not remind you why our Constitution prescribes that our presidents be sworn in during the day. We were all adults, we know where that comes from. It's one of the most autochthonous provisions of our Constitution. And therefore, when things happen in the night, we have reason to have our antennas high. Between the time Senate rose on the night of 17th October 2024 and the time we woke up in the morning of 18th October 2024 to the President's communication to the National Assembly, we were told that the IEBC, which we now know is not properly constituted, has no commissioners, had purportedly cleared Honorable Kithure Kindiki in the night. I'll not say much about KRA because I think KRA can work overnight and will not complain. But it was that memorandum. The other culprit was the president himself. The president of the Republic of Kenya undertook these clearances overnight and in the morning had a clear proofread memorandum. Exceptional efficiency, we celebrate that, to Parliament. Then the National Assembly itself. Now, this is curious. The National Assembly itself had called a sitting prior to the resolution of the Senate. The sitting was called prior to the resolution of the Senate. To sit on a day, ordinarily not a day of sitting of the National Assembly, to process a resolution of the Senate it had anticipated, the removal of a deputy president from office, and processing clearance or approval of another deputy president. We sit here as judges, we sit here as court assistants, we sit here as advocates representing various parties. I don't know who among us, once we take away the clocks of the official roles we play, was proud as a Kenyan observing these events as they happened. I don't know who among us was proud now putting on the cloak of citizenship to watch these events unfold at that pace. Fortunately for us, my lords, my ladies, we have a judiciary of Honorable Richard Mwongo that arrested this process in its tracks to give the Constitution a chance to roar. In the far corners of Kerugoya. Fortunately for us, we have the judiciary of Honorable Chacha Mwita, His Lordship, that arrested this process to give the Constitution a chance. Today, you sit and I stand before the judiciary of Honorable Ike Ogola, Honorable Esim Rima, and Honorable Dr. Frida Mugambi that has been invited by the respondents to undo that chance that the Honorable Mwita and the Honorable Mwongo gave the Constitution. We don't begrudge them for that invitation. Because under Article 48, they are entitled to come here and make that invitation. Our question is whether the judiciary of Honorable Gola, Honorable Mrima, and Honorable Dr. Frida Mugambi will be baited by that invitation. That's our only question. Throughout these proceedings, we shall be looking at you in the eye to ask, will you fall for this bait or will you stand for the Constitution? Having laid out our broad attitudinal view of this matter, allow me to address you now on the law and the jurisprudence of conservatory orders. In terms of textual prescription, in terms of the prescription of text of the Constitution, we will find accommodation for conservatory orders in two aspects of Article 23, Clause 3 of the Constitution. Article 23, Clause 3 says, in any proceedings brought under Article 22, a court may grant appropriate relief. So we find accommodation of conservatory orders in the use of the phrase appropriate relief, because appropriate relief is wide enough to accommodate anything under the sun that is necessary to give effect to a right, fundamental freedom, or I dare say, any other provision of the Constitution. The second accommodation is in paragraph C of clause 3 of Article 23, which says, in any proceedings brought under Article 22, a court may grant appropriate relief, including, say, a conservatory order, expressly. I'm a bearer of good news that in determining whether or not to grant conservatory, to confirm these conservatory orders, my lords, you need not look further than in the files before you. I'll demonstrate you shortly. Just by looking at the files before you, you will see why you must confirm these conservatory orders. Let me go there. Allow me to address the brief issue of your jurisdiction over this matter from the files before you. I would invite you, when you retire, to look at the ruling of your brother, Justice Mwita, of 15th October 2024 in petition number 550 of 2024. When you look at that ruling, I would invite you to look at page number 7 of that ruling. There is a paragraph 7. The way that ruling was processed was that each theme, the judge addressed it by beginning with paragraph 1 to the last, then another theme, paragraph 1. So you start off paragraphs 1, 2, 3, then it ends, and you begin paragraph 1 again. So you look at the paragraph 7 at page 7 of that ruling of Chacha Mwita in petition number 550 of 2024. For the benefit of this court, for the benefit of everybody who is listening, Honorable Chacha Mwita said the following things in paragraph 7, that the petitioner also argues that constitutional imperatives in conducting public participation were not met. The claim falls within the scheme of Article 165(3), so that this court has jurisdiction to interrogate whether any of constitutional processes said to have been conducted under its authority met the constitutional threshold. The judge has already established that the argument on public participation raised by the petitioners falls within the jurisdiction of this court under Article 165, Clause 3. Then, paragraph 9 of that ruling on the same page. Justice Chacha Mwita holds, first he observes that the first respondent has pushed an argument that this court has no jurisdiction to hear a matter arising from impeachment of the president or deputy president on the basis of Article 165(3)(c). Then he reproduces the provisions of the article verbatim. I wouldn't want to regurgitate that because you'll read it. He proceeds now to argue that Article 165(3)(c) is in relation to the process of removing the president or a deputy president from office on grounds of incapacity. This process is initiated for purposes of investigating the president or deputy president's physical or mental capacity to perform functions of that office. And here's the clincher. This is a distinct process from that of impeachment in Article 145 as read with Article 150. Article 163(c) excludes jurisdiction of this court over the process undertaken in accordance with Article 144 and not Article 145 as read with Article 150 of the Constitution. Honorable Chacha Mwita has made a finding that this court has jurisdiction over a matter or a process undertaken under Article 145 as read with Article 150 of the Constitution. If you turn to page 9 of that same ruling, of Justice Chacha Mwita of 15th October 2024 in petition number 550, page 9, you'll find another paragraph 4. I think I explained why these paragraphs run back and forth. Paragraph 4, he says, I'll read paragraph 4 and 5, so for full effect. Paragraph 4, Article 145 lays down the procedure to be followed in cases of impeachment and the timelines for doing so, including affording the person an opportunity to be heard on the charges. I have considered the constitutional provisions on impeachment and read decisions from the Supreme Court and the Court of Appeal, which are binding on this court. These decisions have laid down the position that it is important to let the impeachment process run its course, after which the court would have a look at any complaints on violation of either the Constitution, the law, or fundamental rights, including processes. After which the court would have a look at any complaints. He's again asserting the jurisdiction of this court at this stage. Then, I would also invite you to look at at page 10 of that same ruling. At that same ruling. And this is the clearest warning that Justice Chacha Mwita was sending to the national executive and the national legislative institutions, parliament. At paragraph 9 on page 10, he observes, in other words, constitutional processes are not about dashing to the finishing line, which is what they were doing. It's not about that. We are being told what you are doing is child's play. And we are not here about child's play. We are here about the Constitution. He says they have constitutional imperatives that must be complied with. And if not, such infractions will not be out of reach of our Constitution. He completes by saying, where there is an allegation that fundamental imperatives in the Constitution have not been complied with, which is the allegation that you have before you, my lords, my lady, the affected person, my client, His Excellency DP Gachagua, has recourse to court, and the court will have to determine whether the state organ complied with the Constitution or the law. Has recourse to court. I began by saying, we need not look further than in the files before you to assert that these orders have been confirmed, and I'm beginning by confronting the unfortunate allegation of lack of jurisdiction that has been filed on behalf of the person who was nominated to be the deputy president and who is supposed to uphold the Constitution. At paragraph 10, he gives the most enduring philosophical statement of page 10, paragraph 10, page 10. In that respect, our Constitution offers both hope and promise. Hope that the institutions it has established will comply with its fundamental principles. We now know that that was hope against hope. And promise that the Constitution is supreme, and any act or omission in contravention of the Constitution is invalid. In other words, it does not matter how far the process may have gone, since no action is beyond the reach of our Constitution. My lords, I want to speak the truth here. In the face of these pre-existing rulings in these files, you will hear arguments here of non-justiciability of this dispute, political question doctrines, things that have been fished in a cut and paste manner from old American jurisprudence into a transformative constitution of the 21st century. I mean, that's unfortunate. I am hoping that once I'm done with this, those who came to court carrying those arguments of political question doctrine, non-justiciability, will find favor in abandoning them to save us some time. At the same page 10, you'll find another paragraph 1. I tell you the judge was starting paragraph 1 at every new issue. He says, Article 2, Clause 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by constitutional dictates for any act or omission in contravention of this constitution is invalid. That's what the judge is telling us. When you look at the files before you, my lords, you'll also find the ruling of your brother, Justice N.N. Mugambi, in petition number 522 of 2024, His Excellency Rigathi Gachagua versus the Speaker of the National Assembly and others. Another file that is before you. At page 9 of that ruling, you will find paragraph number 34. In that paragraph, the judge observes, and that was when he was delivering the ruling to send this file to the Chief Justice to empanel the three of you to sit. He says, Article 165, Clause 3, Paragraph B or D of the Constitution has been delineated by Article 165, Clause 4 as constituting areas from which substantial questions of law might arise to require composition of a bench. He then goes ahead and reproduces Article 165, Clause 3, B and D. He's saying, before he sends this file to the Chief Justice to empanel a bench, he must satisfy himself that the dispute in question falls within Article 165, Clause 3, Paragraph B or D. And he made the determination that the dispute falls within Paragraph 165, Clause 3, Article 165, Clause 3, Paragraph B and D, and send the file to the Chief Justice to empanel the three of you. The three of you are sitting on this bench on a finding that the court has jurisdiction. In the absence of that, the dispute would have been outside the ambit of Article 165(4) for empaneling of a bench. Then there is your own jurisprudence as this bench. "13 days ago, on 16th of October, 2024. 13 days ago, the three of you, my Lord Justice Ogola, my Lord Justice Mrima, my Lady Justice Frida Mugambi, delivered yourselves on this question of jurisdiction. In that ruling, in petition number 522, as consolidated now with the others, in that ruling that you delivered on 16th of October, at paragraph 83, you observed that at the moment, that was at that time, this court is being called upon to anticipate the outcome of a process yet to be completed. The application at this point is premature and anticipatory. In any event, should the petitioners not succeed before the Senate, they still have an opportunity to approach the courts. The applicants cannot therefore say they have no remedy. Now, I was asking myself as I prepared, I'm imagining you now telling us, no, you have no jurisdiction. Having told us this, my lords, how will you look at each other? How will you look at us? You told us yourselves, go to Senate. Once you have finished, come here. Then we come here and you agree with my friend, Dr. Mudomi Thiankolu. These are political questions, and therefore we cannot deal with them. These matters are unjusticiable. How basic decency militates against at least the three of you, saying you have no jurisdiction. I respectfully submit, my lords, my lady. You observe that paragraph 85, that this court, and I was asking myself, what does the word this court mean? this court means two things. You said, this court has unfettered jurisdiction to check the constitutionality of the process at whatever stage. As such, we are certain that the petitioner's rights are currently well guarded and none of the petitioners stands to suffer any prejudice. You assured us that you have unfettered jurisdiction, that's what we used, jurisdiction, to check the process at whatever stage. I've said the word this court, I understood it to mean two things. One, to mean the High Court, because you are talking about this court. I don't think you had forgotten you are judges of the High Court. So that when somebody comes and says, we ought to have gone to the Supreme Court, they must also justify it in this context. And number two, it means this bench, the three of you sitting here as a bench, you are now this court in this matter. You have unfettered jurisdiction to check the constitutionality of the process at whatever stage. At paragraph 87, you reiterated that you are exercising judicial restraint in order to accord constitutional entities the latitude to deal with their mandates. But then you said, we however clarify that courts can and ought to readily intervene in ongoing processes before any entity in the clearest of cases where there is evidence of flagrant and gross violation of human rights and fundamental freedoms. I began by telling you, the most flagrant is the happening of 18th of October, 2024. The most undebatable. The National Assembly received a nomination of Honorable Kithure Kindiki from the President. The National Assembly had in its face Article 118 of the Constitution. In its face. I'm sure some members are sitting here of the National Assembly. They had in their face Article 118 of the Constitution. That article continued to pronounce itself because Article 259 says the law is always speaking. So this article was consistently speaking to the National Assembly, consistently speaking that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The law continuously spoke. The Speaker called the House Business Committee. They met. Article 118 was speaking to that committee that you shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. That committee turned a blind ear to this speech by the Constitution. They sat in plenary. Article 118 1B was speaking that you will facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The plenary turned a deaf ear. Two, this dictate. The most blatant. I want to ask how we cannot stop the confirmation, the assumption of office of Honorable Kindiki on this argument only until we argue this matter fully and settle it at the hearing of the main petition. I want to see. I'm a career learner. If you convince me, I can tell my clients they have convinced me. But I'm trying to imagine the kind of philosophy you will require to convince me. The 50 million Kenyans out there know none of them was ever called upon to make any view, any thought on the suitability or otherwise of Honorable Kithure Kindiki to be the Deputy President of Kenya. They know. Then, at paragraph 90 of that ruling, you observed, in other words, this court is still able to grant a remedy even after the process in Parliament is concluded. You again asserted your jurisdiction. I want to conclude this aspect of my submissions, my lords, my ladies, by pointing out that it's a high time that we laughed out of this court anyone who questions the jurisdiction of this court in this matter in view of all these prior rulings in the files before you. Allow me to then briefly address you on the other aspects of issuance of conservatory orders. Again, I will not go further than your own earlier rulings. In your ruling of 16th October 2024, at paragraphs 62 to 71, you pronounced yourselves on the principles that govern grant of conservatory orders. We agree with each of those principles that you set out in that ruling without any modification. We agree with each of the principles that you set out in paragraphs 61, sorry, my apologies, 62, all the way to 71. I will address myself to only one aspect of those principles and invite my learned colleague, Mr. Macharia, to address the remaining aspects. This is where you allude to the case of Gatirau Peter Munya versus Dixon Mwenda Gidinji and two others. If I'm not mistaken, this must have been the matter that was argued by my colleague, Dr. Tiankolu, some times back, so he would know it very well. It was among the first cases to deal with this matter. It's actually the first one in the Supreme Court of Kenya. You see, we celebrate Dr. Mudomi Tiankolu for contributing to this kind of jurisprudence. He observes, and I quote, that conservatory orders, consequently, should be granted on the inherent merits of a case, bearing in mind the public interest, caution of values, and the proportionate magnitudes and priority levels attributable to the relevant causes. I want to address myself to the inherent merit of this case and just on one aspect of public interest. In fact, let me just begin by putting aside the issue of public interest, by asserting as a principle, my lords, that I desire that you hold that the greatest public interest is upholding our Constitution. There can be no superior public interest attributable to politics or other considerations that would outweigh upholding our Constitution. In fact, that is my understanding of Articles 2 and Article 3 of the Constitution. Articles 2 and 3 of our Constitution provide that the greatest public interest is in upholding our Constitution. I can see my learned colleagues jittery. I don't know whether they want to raise an objection. Okay, thank you.
Not me. I would never raise an objection regarding you.
Thank you so much, my teacher and mentor, Professor Gedum Muigai. And I'm sure our other colleagues have taken cue from you, Prof. So that, my lords, when a petitioner raises a matter like the clearest violation I have raised on what transpired on 18th, there can be no greater public interest than giving that matter a chance to be ventilated fully. I can't imagine of any. But having said that, let me now deal with how this petition meets the inherent merits test.
Just a minute, sir. We had earlier on given a time allocation, which Mr. Kibe disagreed with and asked for 2 hours. We will give you that 2 hours and not beyond. You have done 1 hour.
Okay. Let me now take 15 minutes to summarize the rest of the argument. Then we see how to wind up that. So let me address the issue of inherent merit, because that's my last argument. Then I can see what my learned colleague, Mr. Masharia, can mop up. We had gotten another indication, my lord, that we have the whole day. That's the last direction you gave before this one. So that's why your words, my lord. I'm sure the transcript will come out with those words.
That is, we speak as Africans.
Let me do the best I can in view of the new direction, because that has made me now to change my approach. Which can
Certainly, Mr. Ongoya, you didn't expect that we have the whole day. We had given directions on time,
yes,
and on your own authority of Mr. Kibe, he said you would want 2 hours. And we have agreed to that. So let's stick to the petitioner side having 2 hours.
Let me give it my best. We'll deal with the eventualities. Allow me then just to refer you to a few things. On your ruling of 16th October 2024, at paragraph 78, you observed, and I quote, "In sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law has been contravened or is threatened with contravention." Then you at paragraph 79, you observe, applying the above in this matter, petition 522 that is before you now, without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration. You made a finding that the case has inherent merit. You could see it without much ado. At paragraph 93 of that ruling of 16th of October, you observed that we have no doubt in our mind, your mind was clear, my lords, that this matter raises issues of immense public interest. A matter that raises issues of immense public interest, we argue, is a matter that is infused with inherent merit. When you consider the ruling of your brother, Justice Chacha Mwita, at page 9, paragraph 3, in petition number 550, which is now before you, the judge observes, and I quote, "There is further argument that constitutional imperatives on public participation were not complied with. The petitioner has given an example of Keio South constituency to demonstrate this fact. According to the public participation results for that constituency, the total number of people who participated is given as 43. Those who are in support are given as 70. Out of 43 participants in a public participation event to remove DP Gachagua, out of 43, 70 approved." Well, that's the case before you. This is how we have treated His Excellency, Rigathi Gachagua, my client. Those who did not support were 3. They also got those who did not support. Having gotten 70 out of 43, there has some residue of 3 not to support. The percentage of those who support was 162.79%. We used to distinguish law and mathematics by saying that mathematics gives us instruments of mathematical precision. I don't know what the National Assembly will do with this mathematics, but this is curious mathematics. The judge now observes, it is implausible that an attendance of 43 people will produce 70 people in support and 3 in opposition. I submit that there was no remedial measure to this blatant failure by the Senate. There was no remedial measure. This poison has worked with this dispute throughout the process up to the time we come here. I'm making out a case that this case has inherent merit by these findings. At page 11, the judge referred this matter to the Chief Justice to empanel a bench on finding that the issues raised in this petition were immense. Again, that speaks to the inherent merit. When you look at the ruling of Justice L.N. Mugambi of 11th October 2024, all the way from paragraph 38 to paragraph 42, the judge highlights the matters of grave significance that this petition raises as a precondition to referring this matter to the Chief Justice. I submit that this speaks to the inherent merit of this case. And finally, at least for my part, when you look at the order from Kerugoya in petition number E15 of 2024, which is before you, at order number 3, the judge observed that the matters raised in the petition being of great national importance and urgency. He then referred the file to the Chief Justice. And I have two observations to make here. The finding that the matter was of great national importance and urgency speaks to the inherent merit of this case. If you look at order number 5 of the order of your brother Justice Mwongo, he gave the Conservatory order because of the finding in paragraph 3, in order 3. He says, in light of the nature of the matters raised as noted in order 3, a Conservatory order be issued. I want to submit to the nature of those matters has never changed. For you to vacate this order, you must convince yourselves, convince us, and convince the entire Republic of Kenya that the nature of these matters has changed. The matter has remained as it was on 18th of October 2024, which was the basis for the grant of Conservatory orders. I therefore submit as follows, that because this bench, Justice Mugambi, Justice Mwita, and Justice Mwongo have, in the various rulings above, already found that this matter has inherent merit. It is not open to the respondents in their application for setting aside to invite this very court to revisit that matter and reach a contrary finding in the face of the principle of res judicata that you considered and applied on 16th of this month. I also submit that because the 4 benches I have alluded to have consistently found that this court has jurisdiction, it is not open to the respondents to argue that this court has no jurisdiction and invite this court to enter a contrary view without violating the principle of res judicata that you used against the petitioners on 16th of October. I trust that my learned colleague, Mr. Masharia, has taken note of the time and therefore he is able to compress arguments so that we pave way to the other petitioners. I urge that you grant the Conservatory orders in petition number 565 of 2024 and in petition number 15 of 2024 at Kerugoya to preserve the subject matter and to give these parties a chance to ventilate themselves on the merits in the main petition. Over to Mr. Macharia.
If it pleases your ladyship and my lord, I will speak to three issues. The first of those issues is an issue raised most robustly by my colleague, I believe it's Dr. Yankolu, and it is the question of political question. The second issue, my lord, my lords and your ladyship, will be the question of fair hearing. And the third one will be jurisdiction in the context of Article 40. Let me begin with the last one. In response to what the petitioners will tell you this morning, you will be treated to the most astonishing claim in our 10 years of the Constitution 2010. You will be told that the National Assembly and the Senate and the Executive have a dictatorship, have an autocracy on political questions, that those questions cannot be questioned by this court. That is the textbook definition of dictatorship and autocracy. The Constitution of Kenya, beginning at Article 1 and going to Article 10 and on to the end, is replete with the word accountability. Kenya is not a presidential democracy. Kenya is not a legislative democracy. Kenya is a constitutional democracy. When we gave ourselves this constitution in 2010, we introduced into it a concept known as limited government. And what that concept means is that those who are accorded powers under the Constitution can only exercise those powers within the four corners of the power granted to them. That is number one. And that number two, on account of Articles 1, Article 2, and 3, all those decisions are amenable to judicial review for purposes of confirming compliance with the Constitution. My good friend, Mr. Dr. Fiankolu and his colleagues have in the submission cited to you a case which they have extracted from the Sonko, allow me to call it that, the Sonko Supreme Court decision. They tell you that on the basis of a decision called Nixon versus the United States, you have no jurisdiction on account of the political question doctrine. But what they've done actually is that they cut out the passages and left out the decision that the court actually made. This is what you will find at paragraph 113 of the Supreme Court decision. And so far, it's the only, I think, full decision by the Supreme Court on the question of impeachments. Full decision after an impeachment. This is what they say. In that sense, and and this is now a continuation from where the respondents here have cited in their submissions. In that sense, and in the exercise of these wide political powers, both the County Assembly and the Senate cannot act outside the confines of the Constitution. So that's the first point. The Senate and the National Assembly, even while acting politically, cannot act outside the confines of the Constitution and the law. That's number one. And they then say, and this is where you draw your jurisdiction from, for to do so would invariably invite the court's intervention, which is what we're asking you to do here today. They then cite the case of Nixon, which itself stated that there must be judicial review when state organs or state bodies misbehave. But this is what the court says. Courts are thus permitted to intervene where matters of constitutional violations arise. And that's not the only one, of course. We've cited before you other cases, including the Wambora decisions where the court, both the Court of Appeal, went to great lengths to explain where you draw your jurisdiction from. So I believe the Supreme Court decision in the Sonko case should put to rest the question as to whether you have jurisdiction even on political questions. The respondents then make another submission. This is that this court lacked jurisdiction because jurisdiction to interrogate the presidency and its appointments or elections lies exclusively within the Supreme Court of Kenya. They don't say so explicitly, but they say so by way of example. And they tell you that under Article 164, I believe it is, Article 163, sub-Article 3A, the exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the president arising under Article 140. It's important to linger on every of those words. The exclusive jurisdiction is limited to elections, number one, arising under Article 140. And there's a reason it's worded this way, and here's the reason. Now, not every election is a presidential election. Now, under the definitions set out under the Elections Act, the Elections Act is itself a statute promulgated by Parliament under the provisions of Article 82 of the Constitution of Kenya. It recognizes only 3 types of presidential elections. The first is Article 136. It is that election that leads and that has the qualifications and the mechanism for it under Article 138 that then leads to a petition in the Supreme Court of Kenya under Article 140. There is then another election under Article 139, sub-Article 1B, and you'll find this in the definitions of the Elections Act. And the third presidential election understood is Article 146, sub-Article 2B. A replacement of a deputy president under Article 149 is not an election. And I must confess that Article 149 was perhaps not worded very elegantly, because what Article 149 does is that Article 149 almost seems to have ended prematurely, because it says within 14 days after a vacancy in the office of the deputy president arises, the president shall nominate a person to fill the vacancy. So it's a nomination. The word used there first is nominate. A person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. It doesn't say anything after that. But one of the things I found when I examined another statute with similar provisions, this is Section 32D of the County Governments Act. Section 32D of the County Governments Act is actually a lot broader. It explains how that vote will be conducted, the time periods for it, the threshold for that vote. It's a lot more elaborate. But one of the things it makes clear is that the vote akin to Article 149 is an approval. It's not an election. It's an approval. And if one were to examine the Constitution further, everywhere the word election is used, and just by way of a few examples under the Constitution, Article 86, Article 87, Article 83, all of those articles, including the powers and functions of the IEBC, which my learned friend Mr. Ndegwa will be speaking to later, all of those make it clear that the election contemplated is a contested election with voters under Article 1. 14 million Kenyans. That is what the Constitution understands as an election that then invites the jurisdiction of the Supreme Court of Kenya under Article 140. So it cannot be that the respondents get to make 2 opposing arguments. They argue that because This is the argument. This is an election. So you can only go to the Supreme Court of Kenya. But they then argue, this is not an election that requires the IEBC. That's one of the things they've argued. Because an election requires the IEBC, as properly understood. So even that argument that the Supreme Court of Kenya is the only one that has the repository of jurisdiction to determine this matter does not find any basis, doesn't find any grounding in the Constitution of Kenya. You can also look at Article 106(2)(a) for what they discuss when they talk about an election. So Article 149(1) does not envisage any contest. The president nominates one name. And while I'm here, let me deal with an elephant that my learned colleagues will be throwing at you. It's actually more of a monster. In response to what we are telling you, they will tell you there's a public crisis of monumental proportions, not seen since the late Daniel Arap Moi told us that he will appoint a vice president if it increases the sufurias of ugali in our houses. We were told this is the worst thing that has ever happened. There's a vacancy. Answer number one, Article 148 does not 148, sorry, I believe I'm talking about the sequencing where the Speaker of the National Assembly is the third in command, so to speak, when there's a vacancy. I have been waiting for my good friend, Mr. Milimo, who represents the Speaker, to shoot up to his feet and protest loudly that his client is not a vacuum. Because the Constitution says, when, I think it is, this is Article 146, Subarticle 2B. If the office of Deputy President is vacant, or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of the President shall be held within 60 days after the vacancy arose in the office of the President. Two things to note there. In that article, the framers of the Constitution contemplated a vacuum in both the presidency and the deputy presidency. And it is at this point where my good friend Mr. Milimo says his client Anatosha. Maybe you'll say it. I am almost certain in the event that my good friend Mr. Kamoto described here a few days ago, when he said the president might go to where people don't come back from, that we will all say Wetana Tosha. He did. The record says. Yeah, but we understood him. He was not wishing ill. So that's the first thing. The second thing, my lord, is that they contemplated we can operate for 60 days, 2 months, without either a president or a deputy president. The world will not collapse. Kenyans made adequate arrangements for the caretaker, while those two are not with us. And there seems to be something magical about these 60 days that Kenyans clearly had. Because under Article 149(1), when the deputy president is impeached or there is incapacity, the president has 14 days to nominate a candidate to the National Assembly. That is number one. And because it is not obvious, or it is not a matter of course, that the National Assembly will approve that candidate, it must be contemplated that the National Assembly can refuse to vote for that candidate. So those 14 days can be repeated, which is what the Constitution says. If Parliament rejects the first candidate, the process is repeated again. And the Constitution seems to contemplate can be repeated almost indefinitely until the president comes up with a name that is acceptable. So that is number one. And there's no crisis. The world will not end as Parliament rejects those candidates. So that's number one. But the president having nominated a candidate, the National Assembly itself has then another 60 days. So we can again operate as a country for 60 days without a deputy president. And so I return to what the Supreme Court said in the Sonko case we must do, and has not been done, has not been afforded to our client, the Deputy President. This is what the court says. This is the Supreme Court again at Article 114. And it's interesting because what had happened in the Sonko case, the court actually found that Sonko was not properly before it. But they then said they converted the proceedings into an advisory opinion. So they're actually giving this as a template for courts such as this honorable court to follow. Article 114, paragraph 114. To the question whether due process was followed in the removal of the appellant, the audi alteram partem rule requires that those who are likely to be directly affected by the outcome of a decision should be given prior notification of the action. So they give a whole list of what must be done. Prior notification of the action proposed to be taken, of the time and place of any hearing that is to be conducted, and of the charge or case they will be called upon to meet. They must be given an opportunity to be heard. Now, it is not a matter in dispute that on the night the Senate, I and my colleagues on both sides were present in the Senate, our client was taken ill. I have subsequently read in the newspapers, he had a broken heart for good reason. So he is taken ill, and the Senate then takes a vote. And this was important because the Senate had 2 days left, even in their own self-prescribed time limits. They voted, and this was not an electronic vote. They voted on acclamation to reject a motion to extend time for the Deputy President to appear
My Lord, if I may, I am compelled to interrupt. My Lord, learned counsel is misleading the court. When on affidavit, it is clear that the Senate votes electronically. Senate does not vote by acclamation. I do not know what paragraph is addressing himself. Perhaps he can point to the court to the paragraph he's addressing himself to on the question of acclamation. We can't just sit back and watch Mr. Macharia mislead the court.
I was personally there. Senior Counsel Mwite was there. The entire team, most of them were there. On the question of extension of time, it was by acclamation. All the ayes and all the noes, that's what it was. And the senator was not? Yes. And I would ask him to please wait. He'll be a bit more bothered when I finish with my submission, so he can be bothered fully when I finish. So this is what the court says. They must be given an opportunity to be heard, to call witnesses, to be represented by counsel, to be availed adequate time and facilities to prepare, and if the accusations are proved, to be given the reasons. This is important. The Supreme Court says you must be given reasons for your decision. There are no reasons. They voted on grounds submitted to them by the National Assembly. They did not give reasons for that decision. Of course, beyond there, they are also entitled to challenge the decision. Again, you've been told these decisions are not challengeable. The Supreme Court says the accused must have a right to challenge the decision, if against them, before a higher court or tribunal. At paragraph 115, Article 47 of the Constitution enshrines the right of every person to fair administrative action. The manner of actualization of those rights have been enacted in the Fair Administrative Actions Act. Now, when this Honorable Court retires to do its ruling, I would invite you, with tremendous respect, to pay attention to sections 4 and 5 of the Fair Administrative Action Act. They're important in more regards than one. Senior Counsel Paul Mwite has alluded to the question of public participation, and so will some of my colleagues who will come after me. When the National Assembly conducted what it called public participation, it did not avail to the public the response by the Deputy President. What they did is prepare a charge sheet, a copy of which you will find as Annexure 8 of our affidavit in support of the petition, which for ease of reference is at page 498. That charge sheet asks 3 questions. It first sets out the 10 grounds that the motion promoter had set out, and then asks people, do you agree that the deputy president should be impeached on these grounds? Do you not agree? And then there was a third one, other. That was it. They were not told what his response was, nor was he given an opportunity prior to this process. Because the only way, and you'll find that this is one of the things the Supreme Court says under the Article 47 in Fair Administrative Action Act, the participants in this public participation must know both sides of the story to make an informed decision as the people who voted in this man. The court then goes on at paragraph 116. In the process of removal of a county governor, and for this case, the deputy president, the right to fair administrative action under Article 47 and the right to fair hearing under Article 50 of the Constitution all accrue, and I'm paraphrasing here, to the deputy president before a decision to remove him or her from office is reached. An unfair removal is one which goes against the principles of natural justice, just like I've demonstrated, which implies that no adequate notice was given, that there was bias, and where the hearing was not fair. In our amended petition, which you will see in the fullness of time, we have given particulars of how each and every of these issues was violated. The Senate and the National Assembly, first and foremost, constricted the time allowed by the Constitution for themselves. They cut their own time short. And so no one had sufficient time to do anything. We have said they introduced new evidence as the trial was going. There was panel beating as the matter was going on. And as I've said, there was a lack of fair hearing. Though, this is Supreme Court, though a political process, impeachment is sanctioned by the Constitution and the law and is not a platform to settle political scores. This speaks to what Senior Counsel Paul Mwita said a few minutes ago. It's not an issue of ticking boxes, going into a room and saying 300 of us have said you're a bad man, you must go. You're a bad woman, you must go. You must comply with each and every of the provisions of the Constitution. Bearing in mind that the removal architecture in the Constitution, the law, and the standing orders are designed to achieve accountability, political governance, and personal responsibility, and are not aimed necessarily to find criminal responsibility. On the question of natural justice, this is what, this was a decision by, I believe, your brother, Justice Odunga. It's in our list. This is miscellaneous civil application number 266 of 2017. He cites at paragraph 69 a case, I believe, from Uganda. It is a cardinal rule of natural justice that no one should be condemned unheard. Natural justice is not a creature of humankind. They're asking you to take away a creature, and let me read through what it says. It was ordained by the divine hand of the Lord God. What God has given us, do not allow these respondents to take away from the deputy president. And that any law that contravenes or offends against any of the rules of natural justice is null and void and of no effect. The rule, as captured in the Latin phrase audi alteram partem, literally translates into hear the parties in turn, and has been appropriately paraphrased as do not condemn anyone unheard. That is what the Senate did to the deputy president. You cannot allow their resolution to stand. There is a decision, I will not read this for you, but this is a decision of the High Court, a 3-judge bench, Republic versus National Land Commission. I believe this is miscellaneous application number 266 of 2017. At paragraph 109, the decision of the Supreme Court of Kenya in Speaker of the National Assembly versus Attorney General and 3 others, where the court again restated, the Supreme Court, your jurisdiction in these circumstances. And then to the Senate proceedings I've just read out for you. In the Wambora, in the Martin Wambora case, this is what, this is the case, this is, it's cited in the Mike Sonko-Mbovi case versus Clerk of the Nairobi County Assembly. At paragraph 226, I believe this is the High Court decision. This is what the court said about what my good friend, Professor Ojenda, was getting a bit hot under the collar over. Although it does not fall within our remit to direct the legislature on how to perform its functions. We are of the considered view that impeachment of a governor is a serious undertaking, just like a deputy president, as the end result can lead to the removal of a popularly elected governor. The deputy president before you and the president who ran for election in 2022 were elected by a vote of slightly over 7 million people in this country, out of 14 million people who participated. It's a very serious matter. For this reason, we recommend that it will be desirable that future impeachments proceed through the committee route as opposed to the plenary. This is what the court is saying. We say so because when the special committee is appointed, it has 10 days to deliberate on the matter, thus giving ample opportunity to the parties to adequately prepare their cases. The Senate chose not to avail itself of this constitutional mechanism. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary. The trial of the deputy president was held entirely in plenary. And a lot of things, when you look at the Hansard, for example, there was a lot of issues raised about a will, about a succession matter that has nothing to do with the Constitution of Kenya. When you look at the Hansard, a lot of things that had nothing to do with this constitution, and here's the problem. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary, which can be perceived to be a mob lynching process, which is exactly what happened. That is our submission before you. It is what my late member of parliament from Kangema, the late John Joseph Kamotho, used to call kura ya makelele. Now, under the grounds for granting a conservatory order, one of the issues the court is called to look into is the question of whether the orders or whether the hearing will be rendered academic or nugatory. Now, at paragraph 20 of our supplementary submissions, which are dated 28th of October, 2024, we have cited before you a case by the Court of Appeal, Attorney General versus Matindi, and 55 others, where the court explains the following. A successful appeal is not reduced to a mere Pyrrhic victory or paper judgment. Whether or not a matter will be rendered nugatory is determined on a case-by-case basis, depending on the peculiar circumstances of the case. But ordinarily, the court will grant relief if what is apprehended cannot be undone once it happens, or cannot be undone without undue hardship or expense, or cannot be adequately compensated by an award of damages. The court takes into account the respective hardship that grant or refusal of relief is likely to wrought on the parties. I want you to take my colleagues' submissions where they say, you cannot undo. Once a new candidate for deputy president is nominated and sworn in, they say the court has no jurisdiction to undo that appointment. This is what they're telling you. You cannot undo a deputy presidential nominee who has been sworn in and has taken office. This is what they're telling you. At any length, they tell you, this is a political question, don't even look at it. That's why they began. Don't even look at this. The president knew what he was doing, take him at his word and at his actions. So that's one side of the balance of the scale. On the other, you have a sitting deputy president who is before a court of law as he ought to be. If, in the unlikely event, his petition were to fail, all he does is go back home and we swear in the new one once the petition is dismissed. But conversely, if you swear in a new deputy president, you kick in motion a whole series of events, including a president, a deputy president who is now exercising constitutional mandate, who is chairing cabinet committees, that may ultimately be found to have acted outside the Constitution of Kenya. Doing the road to his village home, all these sort of things. So let's hold our hands until we can determine whether the process that led us to this day was done constitutionally. That is the Peter Gatirau Munya decision. My lords and your ladyship, the decision you make in this matter will echo in eternity. It will be a turning point as to whether we continue being a constitutional democracy or a dictatorship and an autocracy. I beseech you, Do not let us go down the path of autocracy and dictatorship. Thank you for the privilege of your attention and your time. Unless you have any questions for me, I'll hand over to one of my colleagues. Thank you.
Thank you.
My Lord, my name is my name is Kibe Mungai, the team leader Paul Muite Senior Counsel, assigned this application, the one from Kerogoya, to me, Professor Ogada, and Mr. Ndegwa Jiro. As I had already indicated to the court, and with the benefit of the submissions from my learned colleagues, we shall try to do our business within an hour. So I'll start first, followed by Mr. Ogada, and then Mr. Ndegwa, for purposes of presenting that application. My Lord, let me start by thanking the court for the decisions that it rendered on last Friday on the questions of directions that it gave for the hearing of the petitions that are before the court. My Lord, I confirm that the process of amending the various petitions is ongoing and will be filed in accordance with the timelines fixed by the court. My Lords, going by the timelines that you gave, it is also my pleasure and appreciation, and that is in ensuring with the compliance with the Mutunga rules, that it is possible for your Lordship to ensure that in the same way that the month of October, we dealt with the political aspects, with the political phases of impeachment, that it is now possible, courtesy of your directions, to ensure that we can be able to have a judgment on merits for purposes of the various petitions that are before you. That would be an absolutely important issue for this court to remember, because it is being made as if it will not giving due process and ensuring substantive hearing of this matter, that we shall be here until forever. And all these businesses can actually be concluded within the month of November. That being the case, my Lord, by way of introduction, let me say two things in my own words as counsel representing, I believe, the 4th to 8th petitioners who filed the application that is before the court.
The date of your application?
Yes, my Lord, that is exactly the issue. 18th, my Lord. The application was filed on the 18th of October. Yes. Okay. My Lord, 18th, it is supported by an affidavit sworn by Honorable David Muni Mavenge on the same date. My Lord, for purposes of the documents, let me start there. We have filed submissions. The submissions were filed yesterday. There is a supplementary we filed today, and we have filed various responses to the affidavits to set aside that my learned colleague, Mr. Ogada, will be referring to them. My Lord, that being the case, I wanted to say that by way of an introduction, there are two broad issues that I can be able to say. My Lord, thank you. Yes. My Lord, the first issue is that the petitioners moved the court in, petitioners applicants, moved the court in Kerogoya in view of the fact that under Article 3.2 of the Constitutions, every citizen of Kenya has an obligation to defend and protect the constitutions of Kenya. That's a broad mandate. And of course, further to the other mandate, that under the Bill of Rights, from Articles 19 to 23, where the Bill of Rights is being violated, they are permitted to come to this honorable court to seek for the appropriate reliefs. And therefore, that is the basis upon which they came and have moved this honorable court. My Lord, the second broad
the discussion along the topic which they have been given, and thereafter we'll go to the next session before we combine the plenary, so that we can leave here in good time. So I think Patricia, you'll start, then Felicia, and then Matthew Mutiso, along the topic which we've been given, advancing access to justice for all, the rights of the vulnerable groups. So we'll give each and every one of you 10 minutes. And if you go past 10 minutes, I am the only one who is allowed to tell you to stop. But I don't want to tell you to stop, because I can't tell ladies to stop. It's only Mutiso I can tell to stop. So take your 10 minutes, and then we can move from there. Thank you. Patricia had a presentation. Our technical team, has it been put up? Our technical team, Patricia has a presentation which she wants to, I don't know how we'll manage it, because Duncan has taken the podium. Will you manage from there? Okay, thank you, Patricia. I'll sit next to Kimondo as I watch you people.
Thank you. Thank you very much, Judge. This panel was dealing with vulnerable groups, and my presentation focuses on children, and it is basically a review of how, as the High Court, we have applied the best interests of the child principle to enhance access to justice for children. And this principle of best interests is well articulated in those instruments that I have set out there, and each of them actually pronounce that the best interests of the child must be the paramount consideration of the law. So one instance where the court has applied this principle to enhance access of justice and enhance access to justice is where there has been a lacuna in the law. We know that whereas it is clear the procedure to follow when handling children in conflict in the law, the law is silent on what happens when the child transits into adulthood in the course of the trial. So in those two decisions that I have posted there, in both instances, the court cited okay, those who are using the flash, one of the panelists has she's sensitive to the flash camera, so it's troubling to her. Kindly do not flash. That's not on my slides. So yes, so those two decisions, in revising the decisions, the court said, notwithstanding that there is a lacuna in the law, having regard to the best interests of the child, in both instances, they did make a decision. I believe in both instances, the children had committed grave offenses, and the court did mete out custodial sentences to them as they were adults. The other instance where courts have applied the best interests to enhance access to justice is where we are dealing with the troublesome topic of consensual sexual acts between minors. Courts have increasingly said there needs to be a different approach in what has come to be referred to as the Romeo and Juliet relationship. So notwithstanding that the court has held that the criminalization of consensual acts between minors is not unconstitutional, courts have nonetheless, whilst promoting diversion, still held that the sentence should be one that reflects the social realities. And both those decisions did speak to that and say we were actually populating our jails with people who need not be there. The next decision, the next batch, is where courts have applied that principle again to ensure that there is non-discrimination towards children based on their birth, so whether or not their parents were married. So this is the case where, for some reason, the registrar of births had the act said if parents were not married, the father would not be reflected on the birth certificate, and other provisions that discriminated against children born out of wedlock. Again, the courts made reference to the best interests of the child. So there was the registration of births, there was the Succession Act, etc. So a number of statutes. The next one is where the issue was ensuring that a child has access to parental care or their right to identity. And what was being considered here was the parent's right to privacy, where a parent felt being compelled to undertake, well, not a parent, an assumed parent felt that being compelled to undertake a DNA test was an infringement to their right of privacy. Applying the best interest of the child principle, the court held that the child's right to parental care and identity would override that right of that adult because there was a prima facie case. Then that principle has also been applied to safeguard equal parental rights to a child. We will know historically, it was almost cast in iron, the tender years doctrine, but in recent decisions, beginning with SMM versus ANK, the court emphasized that the tender years principle is not an inflexible rule of law, and it would yield to the best interests of the child principle. And in that particular instance, we saw a father having the right to custody of children of tender years. So I'd like to say that in conclusion, what we can observe is that by applying the best interests of the rights, best interests of the child principle, we've been able to enhance access to justice for children. Thank you very much.
Thank you, Justice Nyaundi. Sorry, I'm Felicia Mburu from the Kenya National Commission on Human Rights. And sorry, I'm waiting for a picture to come up so that I can proceed. So when you talk about vulnerable, my topic, it's quite interesting. What I've always wanted to tell the judiciary is that we need to see things differently. How we work, how we operate. It's all about reframing the conversation when we talk about vulnerability, because one of the founding principles of vulnerability is legal capacity. If people have power to make decisions over their lives, to make decisions over, to make particular decisions over their life, over their choices, over who they live with, then we end up addressing the question of vulnerability. So as the Commission, one of the things we really focus on is we try not to limit ourselves to boxes of disability, gender, children, but we look at the question of how do the intersectionality of these things make me a vulnerable person? Oh, finally. And if we could all look up to that picture, it's First of all, welcome to the holidays, but it's very intentional. Again, it's about 12 reasons why Santa is actually autistic. And each of those are very intentional to show you what you don't see when you're looking at vulnerability. So the first thing they say is that he lines up and names his reindeers over and over again. That's a very typical, repetitive behavior is one of the signs and symptoms of autism. He wears the same clothes every day. People on the autism spectrum and neurodivergence, including some types of cerebral palsy, Down syndrome. Also, we have tactile sensitivities, and therefore certain types of clothes will make our situation worse or better. My favorite one is that he has a very limited diet of cookies and milk. Again, people on the neurodivergent spectrum tend to have a limited diet because of gut issues that come with that. But when we think about people on the spectrum, we have a different idea of how it presents itself, commonly known as mwenda wazimu. Half of us, when they come to court, like one of the things I raised when I walked in here was that I questioned, where's the interpreter? Because I'm a little bit hard of hearing at the same time, and there was no interpreter. So I was like, okay, how then do you expect me to participate as a panelist? And I don't know, I can barely hear what is really going on in the meeting. And then, anyway, that was one of the things. The idea why I was particularly sent to have this conversation is to challenge everyone to start seeing things differently. And all of this comes back down to the question of legal capacity. One of the things that I love talking about migrants, when you look at migrants and when they move, they automatically become a person with disability. Article 27 of the, I will be using person with disability, but please keep in mind I'm talking about vulnerable groups throughout. It's just disability tends to be the most marginalized of the marginalized vulnerable groups. So when you look at migrants moving from one place to another, for whatever reason, whether it's economic or they're running for safety and things like that, you find that they all have one thing in common. It's a language barrier involved. It's confusion involved. It's limited diet involved. Everything has to be black and white, and there's limited access to information. So then the question becomes, how then do we deal with migrants? Because at this point particularly, they're falling under Article 27 of the Constitution of Kenya. There's some form of discrimination. Just because you've presented yourself in your body and space the way you are, you will form a form of discrimination, and therefore your rights end up being violated. And it all comes down to the question of legal capacity. A good example is my passport. If I walk around without my passport in Saudi Arabia, I have no rights. Anything can happen to me at that point, and my employer can do whatever they want, and I have no redress proceedings that I can go with. However, if I have my passport, if at any point I decide I'm done with this employment, I can walk out. I can leave that country and go back to my home country, and nothing will happen to me. Legal capacity, the fact that I have an identity, gives me my protection. And that becomes the foundation for human rights. Bringing it back to disability, one of the things that I was hoping to project, but it might not, the Article 260 of the Constitution of Kenya highlights disability. This is the definition that includes any physical, sensory, mental, we tend to leave that out, mental, psychological, or other impairment, condition, or illness. Under the United Nations Convention on the Rights of Persons with Disability, that is what we call the medical model. What you're saying is, my disability is the problem. So it's my problem, sort it out. But what does the CRPD tell us? We need to switch it, together with the African Protocol on the Rights of Persons with Disabilities. We need to switch this to a social model of disability. The social model of disability is the environment and the society I live in is the problem. They're the ones who make me disabled. If all of us can accept Santa with all his peculiarities and see him as a nice person, as a human being, and the perfect reason for the season, despite the fact that he's autistic, why then can't we accept our neighbors, our society of persons with disabilities, and just change to suit that situation? Because the idea is, if you have a disability, you don't have legal capacity. But if you give me back my legal capacity, I'm good to go. That same Article 260 of the Constitution talks about marginalized groups. Another area, how the vulnerability comes into this. Marginalized group community is the statement that is used in the Constitution. A group of people who, because of laws or practices before, on, or after the effective date, are disadvantaged by discrimination in one or more of the areas identified under Article 27. So not only are persons with disabilities identified under the disability category, they're also a marginalized group. And this is why I jump into the deaf community and why I love them. The deaf community is a people who have a particular language and a particular culture. Ideally, if we talk to a deaf person in their language, they're no longer disabled. If we talk to a refugee in their language, they're no longer disabled. They're able to participate in court processes by giving them the reasonable and procedural accommodations that they require to go through the court process. However, we go to court and there's a refugee there. One of the hardest languages I've had to deal with was someone who was speaking the Tuareg language. The Tuareg language is completely different, no relational language, and therefore you have to get an actual Tuareg to come to court to interpret it. And he kept asking for accommodations. In the absence of a language interpreter, in this day and age of technology, we find ourselves not able to get internet connection in Niger for someone who can speak to this gentleman in his Tuareg language. But the good thing also was that he's deaf. The deaf is a unifying language. So I was able to communicate with him in sign language, though he was technically speaking French Sign Language, but we're able to communicate. So when we remove our own personal biases and see the Constitution for what it is saying, Article 260 of the Constitution, that the marginalization is not the person. The problem is us, the society, and the environment. By denying someone their legal capacity, we cause the disability, we cause the marginalization. But if we give them their legal capacity in a language and environment and remove the societal barriers around that, we're able to bridge this divide of vulnerability and give people their human rights and their dignity back. Thank you.
Thank you. I'll follow the protocols that have been set before me. All protocols observed. That is me. I work for a coalition for mental health organizations. One of the projects that we are currently working on is volume. Okay, thank you. One of the projects that we are currently working on is a petition in the Constitutional Court to decriminalize attempted suicide. That is petition number 045 of 2022. Professor earlier on spoke about the medical model of mental health, which we've all, I believe we are familiar with. We've heard of issues of chemical imbalances, genetics, and so on. These are some of the issues that bring persons with psychosocial and intellectual disabilities to the courts. But according to us, the court can only do so little about that. Felicia has spoken briefly about the social model, and that's what it means, basically. And then there's a human rights model. It goes ahead to speak about certain specific rights of persons with psychosocial and intellectual disabilities. The CRPD, of course, globalized both concepts. And we know that mental health determinants are based on either social determinants, environmental determinants, or biological determinants. And of course, we have the African Disability Protocol, which complements the CRPD. Next slide. This is a brief picture of what is currently our state of mental health. I won't go so much into it, but maybe I look at the community aspect of care. In high-income countries, access to community care is at least one out of 7 persons can access care. But in our context, there is no care for mental health services. And what, as I proceed with my presentation, I'll show you how prison populations are related to mental health issues from a social determinant perspective. Next one. There was a study that was done in 1986 by the Center for Disease Control in the US, and it brought up these two, we call them realm of ACEs. These are adverse childhood experiences. It says that if you're hit with these adversities between conception and at least the ages of 21, they affect your resilience and ability to adapt, and it creates an affinity towards crime. If you can, you're just maternal depression, some of them we are acquainted with, and also maybe just to give a disclaimer, some of these things might be triggering, but we might see ourselves in them, and also some of the people that we serve. So those are some of the essays that they came out with in 1986. But over time, next one, the essays have expanded. If you look at the first picture, the first part, number 1, they talk about these adversities, but within the household level. And these adversities, what they do is that they affect the children, adults, basically harm children, adults, families, organizations, systems, and the entire community. And they're different. There's one within the household level. There's number 2 within the community. Number 3, environmentally, issues of floods. And number 4, from an African context, you can see colonialism, intergenerational trauma, and so on and so forth. So these are called adverse childhood experiences. And these are the social determinants of mental health, as it's known right now. So what happens to an individual if these ACEs are not intervened properly? The next slide. And that is what, in a continuum, we call a mental health. In different stages of our life, developmental stages, they affect you, they hit you, you develop you manifest certain maladaptive behaviors. For example, you start having emotional deregulation at a certain age. As you develop, as you grow, ages from 8 to 13 years, there are issues of mistrust of adults and authority. There is an aspect of bullying that comes into play. And somebody, as they grow, there's petty offenses. Now this becomes manifestations. And these are what creates or drives people into crime. And perhaps at that age of 25 and 40, you start seeing they look like GBV. They look like homicide, whether it's filicide, whether it's patricide, whether it's femicide, or suicide. And crime in the bigger picture, and imprisonment. And as you develop later on in life, they create what we call disability adjusted life years. They become a comorbidity for these diseases. And this is what, like we say in law, justice is blind to those issues. Justice does not see that, because we mostly, in our traditional way of administering justice, we look at issues of evidence, facts, and so on. We don't look at the underlying social issues, social drivers that could have led people to commit crimes. More often, we don't do that. And that is, the next slide, please, sorry. Basically, that is what our inmates exhibit. If, for example, you took a number of inmates, let's say 10 of them, and asked them certain questions, for example, where do you come from? Majority of them will never tell you I come from Runda or Karen. Majority of them will say I come from Dandora, Kibera, and so on. What is your level of education? perhaps out of 10, one of them has a college certificate. The education law, because they were affected from childhood with the adversities. If you live in a house probably that has an alcoholic person and so on, it tends to affect your memory, cognitive abilities, and therefore you cannot even understand numbers properly. In more often than not, you end up even dropping from school. And so they are related. Poverty, these are the same people who are in prison. Where do you come from? How is your family? They are poor. What has happened to you? In most cases, they have been abused themselves. What do you miss? Love, abandonment, rejection, and so on. And I just put that quote from Hillary Clinton when she was campaigning in 2015. In this context of America, that's what she said. Our prisons and jails are now our mental health institutions. So what are some of the proposals that we are bringing forth in this session? We know basically that's what our traditional courts do. We educate disputes between people or laws of contract, damages, and so on. But for us to achieve the vision of social transformation, we need to redesign the courts. And there's a concept, I believe some of you have interacted with it, it's called the therapeutic jurisprudence. And these are therapeutic approaches that the court can apply to handle some of these social issues that come into court. They appear like suicide, they appear like GBV or other crimes, but they are actually social in nature. We can redesign how we handle legal rules, judicial practices, and so on. We can create problem-solving courts. We have them already applying these principles, for example, the gender-based violence court, but they need to be enhanced. In the US right now, they have about 300 mental health courts, and they have come in handy to solve some of these disputes, which are social and psychological in nature. And of course, the other thing is what we are currently doing, as in line with also CRPD, is to capacity develop judges, magistrates, lawyers, prosecutors, the police, and so on, with tools of assessment, which are more inclined towards social inquiry, the background of a person, and so on. And lastly, of course, promote prevention of crime within the community. Hardly, maybe it's happening, but hardly do you see maybe judges, magistrates within the communities or in schools and so on. Lately, I've seen the other week or coming towards this session, we've seen quite a number of such activities. But we feel like the judiciary can use more of the probation arm as a social function or awareness public angle to reach out to as many people, especially in schools and so on. I think I'm done. Thank you so much.
I think we've done well in terms of keeping time, but I want us to transit into Judge Ougo's panelists so that we can combine the plenary together. Is that working well for us? Because these topics are related, but I've learned a new thing called capacity. And I've learned that if Mr. Mutiso saw me when I was in the village, childhood trauma, we'll pick it up. So just keep your questions ready. Once we transit from Judge Ougo, then we'll combine the two sessions together. Thank you. Clap for me.
Thank you, Judge. Good afternoon, everyone. Are we sleeping? PJ has directed me to direct you to stand up and stretch. Yes. Sorry? You draw a coconut. Judge, come, Judge Grace, and help me draw the coconut. Yes, Smama, PJ's orders, see Ougo.
See, as we just see.
Clap for her. Okay. My panel is going to discuss sexual and reproductive health as a human right, advancing access, equity, and employment. If I could ask my panelists to come up, Lady Justice Wilfrida Okwany Osodo. She'll be followed by Ms. Ham and Alan Maleche. Mr. Alan Maleche. I'm being told that Nerima Were is joining online. Technical guys, is she online? I'm under strict instructions not to read any bio. They're on the screen because we are saving on time. I think the first one that should come up is that of Lady Justice Okwany, be followed by Ms. Hishram. Okay, she said I can call her Said. Thank you. And then Alan Maleche, Mr. Alan Maleche. When Ms. Were comes on board, she will be reflected. You each have 10 minutes, and Judge, you'll be the first one to start. As the President said by Judge Wakiaga, I'll not time you, so you muwe mkiangalia saa. I time you. Aye. Go ahead.
You have slides. Thank you. You have to trust.
Thank you, Session Chair, Judge Ougo. My topic, I'll ask the Secretariat team to send me through the slides. My topic was the role of the High Court in promoting sexual and reproductive health and rights. I'll start by saying that whether we acknowledge it or not, we are all products of sexual and reproductive health rights. And whether we recognize it or not, if you are blessed to be a parent, you are capable of doing that because those rights were upheld or were observed. So straight, I'll go to the definition aspect of my presentation, which is what the United Nations Interagency Task Force says about the definition of reproductive health. And just to bring the point further home, the right of access to appropriate healthcare services that will enable women to go safely through pregnancy and childbirth and provide couples with the best chances of having their babies. Of course, there's also the World Health Organization definition. And then sexual and reproductive health rights, what it includes is the right of individuals to make informed and independent decisions about their sexual and reproductive health without discrimination, coercion, or violence. The right also ensures dignity, equality, and autonomy for all individuals. It includes access to comprehensive healthcare services, education, and legal protection related to sexual and reproductive health. And it goes on to talk about safe motherhood, prevention and treatment of sexually transmitted infections, including HIV and AIDS. So then we'll also look at the legislative framework that we have. And in this regard, I looked at the provisions of Article 43, Sub-Article 1 of the Constitution on the right of every person to the highest attainable standard of health, which includes the right to healthcare services, including reproductive health care. I also looked at the Maputo Protocol over the same subject. When we talk about Article 43 of the Constitution on the right to health, you will realize that our circumstances as a country, we are not yet there. Even just going by the kind of hue and cry we've had with the SHA and SHIF program. So the role of the court, and that is the High Court, in promoting SRHR, I will, in my presentation, borrow the words of Professor Ambani and take the jury optimist approach as opposed to the jury pessimist approach, and just highlight instances where our courts have done an excellent job in promoting the sexual and reproductive health rights. The court has been on the front line in addressing violations of sexual and reproductive health rights, such as forced sterilization, discrimination, gender-based violence, lack of access to safe abortion, and denial of contraceptive services. The court has also reviewed and invalidated policies and laws that infringe on those rights. For example, policies or laws that limit access to family planning services if they are inconsistent with the constitutional guarantees or international human rights standards. I looked at the case of AIDS Law Project versus Attorney General. The court has also ensured the implementation of international treaties in Kenya as a signatory to such treaties. Close to my thoughts was the CEDAW, ICESR, and Maputo Protocol. I noted that there are, however, challenges which have been talked about even earlier in by speakers that came before me. These challenges to the realization of the rights include lack of adequate resources, cultural and political barriers resistant to certain provisions, especially on safe abortion, and gender equality in some conservatory societies. Of course, we are all aware of the LGBTQ rights, which is also a hot, controversial topic. I've looked at case law where courts have made pronouncements, like the case of Matthew Okwanda versus Minister of Health and Medical Services and others, where the court, in recognizing the international treaties, referred to the General Comment number 14 on Committee on Economic, Social and Cultural Rights that recognizes the rights to health, that the right to health is closely related to economic rights and is dependent on the realization of other rights, including the right to food, housing, water, work, education, and all that. I will not tire you with the decision of the court in that you will be able to look it up at your own time. Then there was the case of FIDA, JMM through PKM, and others versus Attorney General and others, where a 5-judge bench of the High Court really discussed at length the role of the state in enacting and enforcing laws and policies that protect women and girls from violence and abuse and provide appropriate physical and mental health services. If you read the facts of this case, if you are not moved to tears, then you will be having a heart of stone, because when you read the facts, what a little 14-year-old girl went through as a result of lack of safe abortion in our hospitals or in our healthcare is anything but excruciating. So the court dealt with the issue of safe abortion in that case. Also, there was the case of JOO, known as JMM, versus Attorney General and County Government of Bungoma, where the court held that the right to health care encompasses proper treatment at hospital, availability of necessary equipment, facilities, and medication, and that failure by a hospital to provide basic provision, such as drugs, was a violation of the rights to health. So in this case, the court emphasized or played its role in advancing the rights to health. Then the court also issued guidelines for obtaining consent in a bid to the protection of privacy or the right to make informed choices. the court gave a raft of guidelines on what is expected of a medical health practitioner in obtaining consent of a patient before conducting certain procedures. So if you look at this and you compare it with the decision in the feeder case, you will notice that if had the healthcare provider complied with those guidelines given by the court, what happens to that little girl would not have happened. Then, of course, my presentation also juxtaposed our decisions with the famous decision in Roe versus Wade, a US Supreme Court case, where the court also dealt with the issue of abortion, safe abortion, and the right of an individual to access abortion. Of course, the case was overturned in a later case that was decided in 2022. But then again, there we are. I can say that we have done well as a court in our role of enhancing SRHR. Thank you so much.
Thank you, Judge. Ms. Said will take us up on the law and FGM. Karibu, Ms. Said.
Thank you very much. Good afternoon, everyone. All protocol observed. My name is Ilham Hisham. I'm representing FIDA Kenya, and I'll be discussing FGM and the law. I don't know if the ICT team can open up my presentation kindly. So as pertains FGM, I just wanted to take us briefly through what FGM is about and the types of FGM. Then we'll cursory look at the international and the regional instruments, as well as some of the declarations and resolutions that have been made. Then make a case maybe vis-a-vis the other East African countries where we are as a country. So generally, there's been over 200 million girls and women today that have undergone FGM. The number might not spell what it actually is, but once we know what actually they undergo as far as FGM is concerned, then we'll be more and more worried as to the numbers. Considering in Kenya, the statistics are that 4 million girls, as per the KDHS of 2014, that's the health survey, 4 million girls and women in Kenya, including those from 22 high prevalent counties, with 21 girls and women aged between 15 and 49 years had undergone FGM. I don't know if it's the sitting position, but the remote is refusing to click. So some of the drivers include, sorry, it's okay. Some of the drivers include ladies and girls being prevented from precarious or sexual exploitation and ensuring that they have their virginity before they get married, and a right as a rite of passage. Apologies for that. So this is the trend. I will share the slides. So in the interest of time, allow me to just skim through. The trend for FGM starting from 2004, 2008, and then coming to 2011, the trend has been on a decline, probably because of also the investment of the government in ensuring that FGM is highlighted and abrogated. When it comes to the emerging trends, we have the age at FGM. This is the age whereby now we see people are being circumcised at infant age. There is a cross-border FGM where now perpetrators are taking the survivors to different countries and counties that do not practice FGM. So this is a new emerging trend. For our Northeastern citizens, most of them, they bring their children from US, UK, and other places to come and conduct it in Kenya in places where FGM is not being conducted. There's also change in the types of FGM. So somebody, maybe they have type 1, and then now somebody does type 3 on them. Medicalization of FGM. 15% of FGM cases were performed by medical professionals. This is as far as the health survey of 2014 is concerned. Then there's also an emerging trend in terms of FGM in emergency and humanitarian contexts. For instance, during the period of COVID, people are more concentrating on COVID and the cases thereafter, but not as far as SRHR issues were concerned. In fact, we were at another seminar yesterday where we realized that 2020 and 2021 is the only period where femicide cases were at a lower rate as opposed to the other years. So the media was more pronounced in highlighting the cases of COVID as opposed to the SRHR issues during that period. So FGM, in Kenya, we have the Prohibition of FGM Act, which was established in 2011, enacted in 2011. We have the types of FGM, the clitoridectomy. This is the partial or total removal of the clitoral glands. Then we have type 2, which is excision. This is the partial or total removal of the clitoral glands and the labia minora. Then we have infibulation. This is where the vaginal narrow opening is covered with a seal. Sometimes it is sewn so that somebody cannot be able to have penetration. And then there is type 4, which is others, where there is piercing, incising, and scrapping. So this is the types of FGM. So there is type 1, 2, 3, and 4. So type 3 is the infibulation, where somebody is just sewn totally. So what are the signs that somebody has had FGM? They normally have health repercussions, and these are some of them, including issues when they are menstruating, giving birth, or urinating, health consequences, including death, apart from HIV and AIDS. Then we had the case of Dr. Tatu Kamawi in Kenya, where the 3-judge bench ruled in favor of against FGM. If the ICT team can play for me the third video, kindly. So in the Dr. Kamau case, the court reinforced the aspect of Article 27 and Article 28 of our Constitution as pertains discrimination and issues of right to dignity. In as much as an adult has the right to consent, that consent has to be measured in accordance with the rights and protection of the others in the community. So while they set up the video, allow me to proceed. Approaches to FGM, there is the human right-based approach, intersectional and survivor-centered approach, as well as trauma-informed practice. Some of the international instruments includes the UDHR. Article 25 provides that everyone has the right to a standard of living advocate for health and well-being. We have also the ICCPR. Article 2 provides that discrimination on the basis of sex mandates the states to ensure that any person whose rights of freedom has hearing recognized are violated and shall have an effective remedy. We also have the preamble to the International Covenant on the Economic, Social, and Cultural Rights, which also talks about discrimination. Then we also have CEDAW, the Convention on Elimination Against All Forms of Discrimination Against Women. In as much as it does not explicitly define FGM, it provides for discrimination and harmful practices. We also have the Convention on the Rights of the Child, which places the government as the ultimate government's responsibility to ensure fundamental rights of the children are recognized and protected. Then we have the international instruments, including the European Parliament resolutions on FGM. We can have a look at that at our own time. Allow me to proceed. We have the Beijing platform on Fourth World Conference on Women, whereby we're discussing about harmful aspects and the rights of women that FGM should be prohibited and eliminated. The UN General Assembly pertaining to elimination of violence against women, and the Commission on the Status of Women as well, which advocated for the ending of FGM. For the regional instruments, we have the Banjul Charter, we have the Maputo Protocol, we have the Charter on the Rights to the Child, we also have the Ouagadougou Declaration and the Cairo Declaration as well. On the Maputo Protocol, Article 5, Subarticle B, clearly provided for prohibition through legislative measures backed by sanctions of all forms of FGM. So this is the first regional instrument that explicitly provided against FGM and sanctions thereafter. There is also abrogation of rights. So some of the rights that one is abrogated as pertains FGM include the right to be free from all forms of discrimination, right to life, right to freedom from torture, the right to health, the rights of the child, as well as right to dignity. Some of the best practices include enactment and implementation of laws and policies in Kenya.
International law, it's no longer arguable. It is in a number of instruments, has been interpreted by a number of treaty monitoring bodies at the international level and regional level as well. I wanted also to highlight the right to reproductive health, which is the focus of this panel, and that this is established under Article 14 of the Maputo Protocol. It is extremely comprehensive and has been lauded as one of the most progressive in the world when it comes to the right to reproductive health. I would have loved to read clause by clause, but the 7 minutes was quite pronounced, so I will also skip through that. So going into the crux of my presentation, just highlighting a few of the issues that courts have interrogated when we look at international treaty monitoring bodies as well as regional ones. There are a few issues when it comes to maternal health care, maternal mortality, obstetric violence, teenage pregnancy and youth-friendly sexual and reproductive health services. And then most interesting is the inevitable tie between sexual violence and the right to comprehensive sexual and reproductive health services. So the courts have really tried to look at how to tie these to the right to reproductive health. And in one of my slides earlier, I had mentioned that the right to reproductive health is inextricably tied to the right to life, the right to dignity, the right to be free from cruel, inhuman, and degrading treatment, as well as very many other rights that are crucial for a dignified life. So the presentation was really about getting into the jurisprudence itself. And this is very exciting for us in legal practice to see how the jurisprudence has developed. And so I picked a few landmark cases that have been decided. So the first one was Aline Pimentel versus Brazil. And in this case, the CEDAW committee was looking at maternal mortality, and they said that it is actually the states that have a human rights obligation to reduce maternal mortality, to ensure women's rights to safe motherhood, and it was actually also an obligation of the state to provide access to adequate emergency obstetric care. So it was not enough for the state to say that, you know, this is an issue of progressive realization, they're doing everything that they can and try to chalk it down to medical negligence. The committee was emphatic that this is an issue of rights and rights being upheld. So then the next case I would like us to look at was again before the Inter-American Commission on Human Rights, and this was a case on forced sterilization. I think my colleague Alan may have spoken about this in the Kenyan context, and this was also happening in Peru in 2003, and this was quite a while ago, where the parties came to an agreement, and Peru was urged to take into account human rights standards in revising its laws and policies on reproductive health and family planning. It was also tied to issues of equality and discrimination for women, which has come across all these cases, particularly the ones before the CEDAW committee. There's been quite progressive interpretation of the tie between the right to equality and the right to reproductive health. So from a human rights standard, it is very clear to and very easy to draw that line and see where the duties lie, what the obligations are, what the standards would be for implementation by the state, and what a failure to implement those standards look like. And I think that was highlighted in this case. And then we have the European Court of Human Rights. So I went up and down a lot of the regions and the international level as well, just to show how the courts have managed to navigate and come to a very clear standard, which is the human rights standard, which I was just speaking about earlier, the non-negotiable, let's say, or the minimum standards that must be met. So in this case of RR versus Poland, there was an issue of access to information, and it was about whether the person who was before the court was denied information that related to her obstetric care, and the court held that the state that was before it was actually in violation of human rights standards and
IT, has she gone off? She's frozen.
Sorry, I dropped off. Can you hear me now? I'm back.
Yes, we can.
Yes. Okay, excellent. And then in another case on the before the European Court of Human Rights, there was a question of the rights of adolescents. And I think this has been quite contested when it comes to what policy should look like. How far should adolescents be able to consent? What is the concept of bodily autonomy when it comes to adolescents to access comprehensive sexual reproductive health information and services? And the court affirmed that young people do have autonomy when it comes to their reproductive health. They should be able to access youth-friendly services, information, counseling that gives them the wide range of services that they should be able to then make a choice as to what is best for them. And then now when we come to our local standards, we had a very interesting case that was decided in 2022 when there was a big issue around Tanzania and access of pregnant girls to school, because the state had a policy where pregnant girls would be banned from returning to school or from attending school. And this was also found to be in violation not only of the right to education, because one would imagine this is purely about the right to education, but the right to reproductive health was implicated quite strongly here, from in the information that is youth-friendly, from family planning and the right to plan their family, which is also actually guaranteed in the Maputo Protocol. And so the African Committee of Experts on the Rights and Welfare of the Child made a very progressive decision requiring the government to take this into account in their legal and policy framework and implementation of the same. It is currently being monitored. The decision is being monitored by the committee as one of their ways of working. And finally, it's not always rosy. We had a decision that was not quite progressive that came out in May this year from the African Commission of Human Rights, where it was the issue of maternal mortality. The rates are very high in Nigeria, and there were claimants before the commission claiming that there was not enough policy and budgetary framework that have been put in place to guarantee the right to life, the right to reproductive health, the right to dignity, the right to equality and non-discrimination. Unfortunately, the commission dismissed the claim, holding that the claimants had failed to substantiate their claims. and also, unfortunately, that they had failed to demonstrate the link between the facts and the infringement that they were alleging, particularly the infringement of rights under Article 14, which I skipped over earlier in my presentation. So while we've had seemingly very progressive jurisprudence, we also have room and quite a lot of room for the interpretation that sits primarily on a human rights, making the human rights as the standard of interpretation, and the standards and the normative standards that have been set out in the legal framework is enough for judiciaries and judges present to make the decisions giving enough credence not only to these legal frameworks, but the jurisprudence that has already been decided. My final slide, I'm actually done. I just wanted to say an honorable mention that we've had quite a few decisions. I just picked out a few that have been decided by our Court of Appeal and our High Courts that I'm sure are familiar to the room, and I think other speakers have spoken about that we are on the right trajectory, but there is still quite a bit that needs to be done, particularly on the issues that I've spoken about, the access of adolescents to youth-friendly services, maternal mortality and maternal health and mortality, and obstetric violence. So I thank you for your time, and back to you.
Thank you, Mr. Ching.
Thank you.
Thank you. This is an interesting topic, but hold your questions until you're allowed to ask them. Let's give a clap to the panelists so that I can hand over to my brother who is coming in next. An organized clap, please. 1, 2, 3. Yes, thank you. Thank you. Judge Moses Ado, or Adu.
At least I'm lucky today. No one has said without much ado. Now, I am here for the next session. It's on balancing justice and human right, examining death penalty and its implications. I will introduce my panelists. The bios, I believe, will be running, if they are not already running on the screen. We have His Lordship, Justice Kanyi Kimondo, who will be our first presenter. But I think the rest can also move from ICJ. We have Julie Matheka. We have Irungu Houghton, Mark Barasa from ODPP. Yes, I think those are the 4 that we have today. Bwana Irungu, karibu. Barasa, karibu. Julie, okay, now we have the 4 of them. I think as the previous panelists, we'll have, with the permission of the PJ, 10 minutes. You may begin, His Lordship.
Good afternoon. It gives me great pleasure to speak to my brothers and sisters this afternoon. I will not be putting anything on the PowerPoint in the interest of time, but I want to say the following. The death penalty is applicable in Kenya for 5 categories of offenses. We have treason under Section 40 of the Penal Code, oathing to commit a capital offense, Section 60, murder, Section 204, which all of you brothers and sisters tried at the High Court, robbery with violence, and attempted robbery with firearms. That's Section 296, subsection 2, and 297, subsection 2. This punishment dates back to the year 1893, just about the time some of you were born. However, the last executions in the Republic of Kenya took place in 1987. It is not very certain, but I believe it was the turn for Hezekiah Ochuka and Pancreas Oteo Okumu following the aborted 1982 coup. Since then, there has been no further execution, and we have had a number of intervening presidential moratoria. For instance, in 2009, by His Excellency Mwai Kibaki. The method for execution in Kenya is hanging by the neck, and it is largely rooted in retribution, and obviously it has significant impact on the well-being of the convicts and their families. Arguments across the aisle on the suitability of this punishment are very forceful. They range from a human rights perspective, that is the inhuman or degrading nature of the punishment, its irreversibility, and dehumanizing nature, particularly for people who have to wait for a long time on death row. Commuting of the death penalty to life, which has been the common practice in Kenya, also means that the offenders continue to serve, oftentimes, an indeterminate sentence. The Moro Teto case, which are framed as part of my topic, did not define that period on grounds that what should constitute a life sentence was not a matter that had been confessed through the High Court or the Court of Appeal. In fact, the court said, and this is good for you brothers and sisters, that it needed to learn from the jurisprudence of this court. In fact, in paragraph 78, they said, a critical issue such as this, where legislation is to be examined, is deserving of the reasoned and well-thought arguments of the petitioners, the DPP, and other interested parties, or amicus curiae, and input of the High Court and the Court of Appeal. So returning to the issue then of the death penalty, there are still arguments again on the other side, that there will be some cases when it's truly deserved. Some murders can be quite gross, some can be fully premeditated, and I've given the example of a decision that I had to painfully make in Eldoret in 2016 in Republic versus Josephat Kipkoech Kirwa, where the deceased was accused of having bewitched a neighboring family. And the key witness last saw this witness hanging upside down on the rafters of a small hut, pleading for mercy and water. The next morning, the witness said that she saw a huge bonfire in that house. And the only thing that was recovered was a few bones. So I said in that particular case, the death penalty was deserved. Remember, this is post-Moro Teto. And the Court of Appeal in Nakuru just this year upheld that sentence. So there are those arguments, and we have to keep them in mind. Although I've made reference to the Moro Teto case, I'm not about to discuss the merits of the Moro Teto case. This is not also a discussion or the interpretation on the Court of Appeal decisions and the High Court decisions that have interpreted Moro Teto to mean that by way of parity of reasoning, mandatory sentences then interfere with our discretion when it comes to sentencing. It is equally not a critique of the subsequent decisions by the Supreme Court, including the directions that the Supreme Court issued on the 6th of July 2021 in Moro Teto. I've used that decision purely as a marker on the road, some form of milestone that shows that the court had a wonderful opportunity before it, but for certain reasons, it could not do so on the 14th of December 2017 when it made that decision. If you doubt that the Supreme Court had that opportunity, you only have to look at the very first paragraph in that decision, and they said that this appeal raises a fundamental legal issue that has engaged many global jurisdictions in seemingly unending controversy, whether or not the mandatory death penalty is unconstitutional. I only want to say this about Moro Atetu. I don't know how many of you remember that this decision was argued twice before the Supreme Court. It was first argued before the bench headed by Justice Mutunga, Vice President Kalpana Rawal, Tunoi, Ojwang, and Wajala J. We call them SCJJ. But then, following the retirement of Justice Tunoi, Justice Kalpana Rawal, and Justice Mutunga, the matter was put again to the new bench that now made that decision. Keep in mind that the main provisions that the court relied on in our constitution is Article 19, I'll not go through it, Article 28, Article 50, Article 25 of the Constitution, among others, including various international instruments